Talking about California courts and the prospective application of laws. California courts follow the statutory construction principle that statutes are to be applied prospectively unless there's clear evidence that the legislature intended retroactive application. So, what are some recent appellate court statements on the topic of prospective application of new laws? Here are two recent ones. The first is California Medical Association versus Brown, a Court of Appeal decision in 2011. The court said, in the absence of a clear legislative intent to the contrary, statutory enactments apply prospectively. In the absence of a clear legislative intent, that was determined by Strauss versus Horton, the Cal Supreme Court said in 2009. They said that the legislative history in this instance indicates that no retroactive application was intended. The legislation had originated in an assembly bill, which, when first introduced, stated that it was the intent of the legislature to enact statutory changes relating to the Budget Act of 2008. This language, which might have suggested an intent to have the legislation apply to a particular loan, was deleted before the bill was enacted. Therefore, the court said we're not called upon to decide whether the loan would have been made lawful under the current version of the government code. The second case is City of La Mesa versus California Joint Powers. And this was a Court of Appeal decision in 2005. The court said that statutes are not to be given retrospective operation unless it is clearly made to appear that such was the legislative intent. One such principle instructs that statutes are not to be given retrospective operation unless it is clearly made to appear that such was the legislative intent. This was also said by the Cal Supreme Court in 1988 in the Evangelatos versus Superior Court decision. In that case, the court said an express declaration of that the legislature intended a statute to have retroactive application is not necessarily required to show that the legislature did so intend. Extrinsic sources may make very clear that the legislature intended to depart from the normal rule of prospectivity. The appeals court went on to say that although the legislature did not use the specific word retroactive or retroactively retrospective when it enacted this section, its explicitly stated intent was that the statute shall not apply to any lawsuits filed on or before May 2nd, 1994. So the court said, short of using the precise word retroactive, it's difficult to conceive a more plainly manifested intent from this language other than that the legislature, by denominating the exact date before which the newly enacted section was inapplicable, that they intended the logical corollary. The statute shall apply to lawsuits filed after that specified date. So, as you've heard in these two appeals court rulings, the courts will review the language of the statute as well as extrinsic evidence such as committee or floor analyses to determine whether there was any intent on the part of the legislature to apply the law's provisions retroactively. If there is no evidence of such intent, then the courts will apply the law's provisions only prospectively.